All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is in re amendments to Florida Rule of Criminal Procedure 3.132, case number 2024-0883. Judge Winokur, whenever you're ready. Thanks.
Good morning, Justices and Chief Justice Muniz. I'm Thomas Winokur. I was asked to appear here by the chair of the Criminal Court Steering Committee on the committee's behalf. As you know, this court asked the committee to consider some amendments, revisions to Rule 3.131 in light of statutory changes, amendments to Section 907.041. The committee concluded that a more substantial revision of the rule was called for, and we're proposing a reorganization of the rule that incorporates the statutory changes, as well as making some other changes we believe were also called for. The committee's report and our response to the other reports address everything the committee thinks that you need to know, and the committee, we're going to rely almost exclusively on that report and the responses for that. But for today, I've identified three areas that provoked a lot of discussion that you may wish to focus on. And given our time constraints, I'd like to just describe those to you here, and then reserve the rest of my time and let the other speakers advocate for or against the proposals. And then I'll just try to address anything that comes up in rebuttal. Those three things are, first, the proposed rule suggests that hearsay alone is sufficient to support pretrial detention in any case, excuse me, whereas the statute specifies that hearsay alone is sufficient to support pretrial detention in the most serious dangerous crimes, and we've said that hearsay should be sufficient alone to support any pretrial detention order. Second, we've proposed altering the level of proof necessary to support a pretrial detention order. This is a change from the current rule, but we believe that it is the change that we've proposed is what the statute requires. And the last thing is we propose a change addressing the necessity for the state to prove a change in circumstances when it chooses to seek pretrial detention, not at first appearance, but sometime after first appearance. Again, we believe that dispensing with the requirement set in some DCA cases is consistent with the statute.
Judge, is it your assessment that as a matter of first principles, just a guiding rule for this court here should be that the rule should square with the statute and not attempt to do anything that the statute doesn't?
Well, that's an interesting question, Justice. You know, obviously, you've got the substantive procedural distinction that has, you know, the correct answer has eluded many Supreme Courts in the past of how to handle that.
This one too.
And well, certainly, I wouldn't presume, but it is a difficult issue, and a lot of times I've seen the court get around that issue by suggesting that as a matter of comedy, this court should simply accept what.
That's so funny, though. Comedy is an interesting word here. Comedy, as I understand it, is a principle that, you know, parallel sovereigns yield to each other, not a principle for dealing with the relationship between the legislature and the courts. That's a matter of separation of powers. I guess my point is, if there are going to be disputes about, say, substantive versus procedural, you know, implications of the rule, isn't it just better to let that litigate itself out and to make it so that the statute and the rule are as closely aligned as possible so that there is a second order litigation about which governs. I mean, we know that the statute would trump anyway. So why not just resolve all doubts in favor of making the rules square with the statute and letting the chips fall where they may on the individual questions?
I think that's a perfectly legitimate way of approaching it. And I do believe that the proposal that is being sent to you does in fact meet that goal.
Okay.
So with that, I will address any other concerns that come up in rebuttal. Thank you very much.
Thank you.
Good morning. May it please the court. I'm Andrew Stanton. I'm here on behalf of Carlos J. Martinez, the public defender for the 11th Judicial Circuit. And I'm here to address in particular the steering committee's proposed amendment to Rule 3.132F, or creation thereof, which would prohibit release on non-monetary conditions at first appearance. And so the question before this court is whether there should be a one-step procedure or one hearing procedure or a two hearing procedure. And there is no reason given for there to be a need for a two hearing procedure. The steering committee says, in fact, well, it's not clear how important it is because it can easily be circumvented by granting a low bond. And I think that's all the court needs to know. A rule that is designed such that it should be easily circumvented to avoid a problem is one that is not fixing a problem. The state says, well, it's important to give us additional time beyond first appearance to investigate and prepare an argument against first appearance. Outside of the pretrial detention setting, I don't think that holds any water. For one thing, what does that have to do with non-monetary conditions? If you need more information to know what the release of someone should be, that applies to a bond decision as well. The only thing that is happening here is a delay, and what happens in these cases is that someone who is eligible for pretrial release and who would have been granted it at a first appearance now has to wait in jail, often over the weekends, until somebody can file a motion to get them out. And that's exactly what happened to Raymond. And that's what happened in a case that's pending before this court right now, Romero. In that case, we have two women who were arrested for domestic violence, and they weren't released on pretrial detention. They were actually over the weekend able to bond out. And thus, there were no sorts of pretrial services release conditions on them. They just had a low bond, and that was the solution in the end. But if the rule stays the same it is, then you could have a one hearing solution where it's appropriate. And if the state thinks that it's not appropriate, they have plenty of ways to tell the court. And I think part of the issue here is, do you trust these first appearance judges at all? Because I think giving them opportunity to set a bond amount, even a very low bond, means that you trust them to make a decision that's going to decide whether or not that person is getting out. And there's no difference in deciding, well, my judgment under these circumstances is there should be pretrial services or house arrest, a greater restriction than a monetary bond might be. So I guess I don't always come up here and say, but trust the judges.
I guess my question is, from my perspective, I don't think it's one of trusting the judges, but I do think, because the trust is what the system is built on. I guess the perspective from which I approach this is that bond tends to be a fluid determination. It may be that at initial appearance, the best defendant can show is a certain amount of contact with the jurisdiction or certain perspective on risk of flight, and a defendant may need time to make a proper showing. Indeed, it's not unusual for bond to be revoked or recalibrated many times before trial. So I guess my reaction is, I don't know how exercised I am by a two-hearing process, because at least in my experience, bond is never just a one-shot deal. Very rarely is bond a one-shot deal. I mean, there are clear cases where you know you're going to get pretrial detention because it's presumed or because it's obvious, and bond is never revisited. But when there are conditions of non-monetary release or monetary release that are assessable, it can be that the assessment changes between the date of arrest and the date on which you file a motion to suppress 2 weeks later or something like that. Given that, what is the trouble with having a second or third or a fourth opportunity for bond to be considered or reconsidered?
Well, one problem is, of course, efficiency necessarily. Obviously, you're right, it does get readdressed very often, release. But you're tying a judge's hands saying, look, you just can't do it. Don't even think about it. We'll just wait until the defendant comes back next week and asks you to consider it again. And it also affects people who, if the court would have, and this is what's happening, would have ordered some form of non-monetary release, right there at the first appearance, that person could have gone home. If the court would have but cannot under this proposed rule, then they sit in jail. And this affects real people who lose real jobs for not showing up.
Is your concern primarily misdemeanor categories?
Candidly, it's solely those cases. Nobody's getting non-monetary release for air piracy. So it would very seldom be of interest there, and it would make sense if there were some way to separate out the land of misdemeanors from this group. But I think that the solution is to allow judges to make the determination in the first instance. And I think that's me counting up instead of counting down. I'm sorry.
Thank you.
Good morning, Justices. Mr. Chief Justice, may it please the Court. I'm Jason Cromie here on behalf of the Florida Association of Criminal Defense Lawyers. Wanted to address first the proposed amendment as it relates to eliminating the change in circumstance for petitioning for pretrial detention at a later date after first appearance. In our experience, as a practical matter, at first appearance, the state has sufficient evidence to at least make the determination as to whether or not it's going to announce that it's going to seek pretrial detention or intends to file a motion. They have the arrest report. They know the allegations. Many times a victim advocate have spoken to the victims. They have criminal history.
So I'm having trouble hearing you. Could you speak up a little bit?
Yeah, I sure can. Yeah. So by first appearance, the state typically has enough information to at least make a determination about whether or not they're going to announce their intent even to file a motion for pretrial detention. They've got the arrest report, they've got the allegations, they've got criminal history. So that's enough to suggest to them this is a case that we should look at, right? We agree with the logic of the First District Court of Appeals that a motion for pretrial detention filed after the entry of a bond order is a modification of bond, and there should be that change in circumstance required. One of our concerns is that if the state has the capacity to file a motion for pretrial detention at any point in the case, then that has the potential to become sort of a bargaining chip or to enter into kind of plea negotiation discussions. A defendant who's out of custody is less likely to enter a plea to a case, more likely to go to trial. And just the mere prospect, and I understand if a defendant's been out on bond for 6 months, then the factors that the court would consider pretrial detention are probably going to be negated by his conduct if he hasn't broken the rules. But even that prospect of potential incarceration can be chilling to a defendant in a criminal case.
Unconstitutionally chilling, or just
no,
chilling in the way that...
just as a practical matter.
Well, yeah, but I mean, that's okay. That's part of the way the world works, isn't it?
Right.
I mean, the rule allows a motion for pretrial detention at any time. I mean, I don't understand how your argument, if your argument is that it is unconstitutional for that pressure to be part of the the constellation facing the state and the defendant, say so. But it seems to me like you're just sort of saying this is the way the world works and it's tough on defendants.
No, I'm not making a constitutional challenge. Okay. I want to make that clear. The way the law currently stands is that a motion for pretrial detention, if filed later in a case, is considered a modification of bond, which requires a change in circumstance or new evidence that wasn't available at first appearance. And we believe that that's appropriate, and that's how the rule should stay. What the steering committee is proposing is to change the current law by amending the rule to make it clear we're outside of that box. And it's our position that that's not necessary, that it just a defendant is out on bond living their life and they have this fear that at any time they could be brought before a judge, despite their good behavior, at the state's request to hold them pretrial.
So you think the change in circumstance should remain?
I absolutely do. Yeah, I think that's the main point. Yeah. The only other issue we would, if I have any time left, I got a minute, I would like to urge the court to to continue to allow the state to have discretion in determining whether or not to seek pretrial detention in the serious dangerous crime cases. Across the state, like the new proposal is not just to set a hearing but to hold a hearing, but across the state, prosecutors are going to those dockets, they're going to those pretrial hearings, and they're not moving forward on pretrial detention. That's just what's happening, but they're in violation of the rule. The other alternative is that they just announce to the court they're not putting on evidence. There can be multiple reasons why the state would decide not to pursue pretrial detention, whether it's the victim's request, they don't want the defendant to be kept in pretrial detention, or whether it's just the nature of the charge or a lack of criminal history, the state doesn't believe it's necessary. But removing that discretion and mandating a hearing in those cases takes time, it takes effort, and a lot of times it's just a futile effort because nothing's going to happen when you get to that court date anyways, and a defendant sat in custody for a week unnecessarily when a bond could have been set in the first place. I appreciate it. Thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. I am Abe Thornburg. I am Deputy Chief Assistant State Attorney in the 20th Circuit, and I'm here today on behalf of the Florida Prosecuting Attorneys Association to express our full support for the Steering Committee's proposal for the amendments to 3.132. I'm happy to address any other issues the Court might have, but my goal is to focus the short time on the practical implications of the proposed changes, as opposed to talking about whether the Court must do it or whether they may do it. I want to talk about why they should make these changes, and essentially it's because they're sound policy. The two main areas really are the change in the burden of proof and the ability for the court to rely solely on hearsay in making that determination about whether pretrial detention is appropriate. And if I may, the same practical considerations, I think, to Justice Curiel's sort of question earlier, are the same ones that the legislature was considering when they were dealing with these things in committee and on the floor. Article 1, Section 14, specifically that second sentence of that section, it's doing two things. First, it's creating a substantive right for most criminal defendants in the state of Florida to pretrial release. And at the same time, it's recognizing that there are competing interests in public safety and in the administration of justice. And there's no real guidance beyond that to the court or to the legislature about how to implement that, or even how long is appropriate for someone who does qualify for release to be held before that release is granted to them. And I think that the court and the legislature have done that job correctly in, first and foremost, doing everything they can to make that period of time as short as possible. And because we don't want to be holding those defendants, who are the majority, who are entitled to pretrial release, longer than necessary. But the flip side of that expediency coin is that the parties are not going to have the ability to have the same quantum of evidence ready within that short period of time as they would in other circumstances. And I can tell you, as a prosecutor and as a member of the FPAA, there are an appreciable percentage of pretrial detention cases that are coming before the court where there is simply not enough time in those 5 days or even the 10 days that were granted with good cause to be able to do all the things we need to do, to locate witnesses, to issue subpoenas, to get those people served, to arrange for transportation for those people, to amass whatever other pieces of evidence we need to meet that burden then beyond a reasonable doubt. And sometimes that's true when the arrest falls immediately on the heels of the report to law enforcement. Maybe those witnesses were talked to yesterday by law enforcement. But in many cases, there's a big gap between the last time those witnesses interacted with law enforcement and when the arrest is ultimately made. And maybe there's a longer investigation, but warrants are the most common time that's implicated. As you all know, a warrant might be issued and not served for months or years, but nevertheless, they're at first appearance tomorrow, and the 5-day or even 10-day clock starts ticking that day. I would ask you to compare the requirements in Rule 3.132 as it stands to 3.191 in speedy trial. When a defendant demands speedy trial, obviously all of the rules of evidence apply. Obviously the burden at trial is beyond all reasonable doubt. And when the defendant demands, the state is given 45 days plus a recapture period to do all of those things that I just talked about, to be able to have their case prepared. And that's true of cases that, of course, at that point we know a lot about. They've been pending for some time. We filed in information under oath on good faith, or sought an indictment and presented to a grand jury. And when we're talking about 3.132, these cases are primarily cases that the state learned even existed the very same day the motion is filed, the very same day that 5-day time period starts. And the steering committee noted in its response to the comments that there's no way of knowing how many cases are denied the motion for pretrial detention because the state was unable to present non-hearsay testimony in that amount of time, or the state was unable to meet that higher burden of proof in that short period of time. And as the FPIA representative, I can tell you we don't have a numerical figure on that as well, but I can tell this court with certainty that this is a regular occurrence, that it is not an exaggeration to say that on a weekly or even daily basis across the state of Florida, there are individuals who should be held in pretrial detention because they are a danger to the community or a flight risk, et cetera, that we are simply unable to do all of the things that need to be done in that short window of time to meet that burden of proof by that evidentiary standard. And it is a balance. It is, we give the state less time to do it because it is important for those people who don't qualify to be released as soon as possible. But at the same time, it's simply unrealistic to expect the state to be able to do all the things that need to be done within that window. 4 minutes is very short, and I'm way over already. So
that's okay. Could you address the change in circumstances issue that the previous speaker raised?
Sure. First, I'm not entirely sure that the steering committee's proposal eliminates a change in circumstances requirement in subsection M, which is the reconsideration. But I think
this is the pretrial detention motion filed after first appearance when the defendant is not in custody. So a defendant is already out. The state decides we're going to file it now. Maybe there's
Correct.
something that and it says if there's something they didn't know, it's not really a change, they just weren't aware of it, then they need not show good cause as previously dictated by our case law. That they had, it was basically like revoking a bond.
Yes, and I think that goes exactly to the point that I was making earlier with respect to the speed with which these things need to move in order to balance those interests to defendants. And there are many things that a prosecutor cannot know. Whether law enforcement knows them or not, or victims know them or not, or other witnesses know them, there are many, many things that we cannot know in that short period of time, especially between arrest and first appearance. And while there are a category of cases that the state must file a motion for pretrial detention at first appearance, there are also a significant category of cases where we may file a motion at pretrial at first appearance. And if we don't have the sufficient basis to file the motion at that time, we have to rely on subsection C of 907.041, which I think is what that subsection is addressing. I think it's appropriate that we not need to show good cause, simply that we have information that we did not previously have, which is not at all uncommon, as I've said. With that, I very much appreciate the court giving us time to give a practical perspective. Thank you very much, Your Honors.
Thank you.
Good morning, Your Honors. May it please the court, Derek Monson on behalf of the Attorney General. So I intend to focus my brief comments today just on why we think it's important for the court to harmonize its rules with the statute more broadly. So first, a lot of my fellow commenters have taken the view that if one of the provisions in the statute is procedural, that this court is free to either reject it, modify it, that the legislation is not binding on that point. As an initial matter, I think I'm not sure that we agree with some of the commenters that it's necessarily clear in all of these cases how the substance procedure analysis shakes out with any of these provisions. But in any event, we would note that even as to procedural provisions, that's not the end of the inquiry, because this court's precedents have allowed the legislature to regulate procedure when those regulations are implementing some substantive provisions. So one example, this court has said that the legislature can regulate the procedures that are attendant to death penalty proceedings because the death penalty itself is a substantive regulation. And similarly, we think that pretrial release, pretrial detention, all these things that affect the liberty interests of criminal defendants are substantive interests that the legislature may regulate, and therefore it is free to also regulate the procedures that are attendant to adjudicating that interest. And then second, even regardless of whether the legislation controls, as Justice Curriel was referencing earlier, there's a lot of value in harmonizing the rules of the statute in any event, because it provides clarity to litigants and to the lower courts about which rules they have to follow. So we've already had a ton of litigation about this statute in the last year. If the rules continue to be inconsistent with the statute, then we end up with kind of a hodgepodge of rules of, the statute governs in some instances, the rules govern in others. The court can cut off all of that litigation, provide clarity simply by harmonizing the rules with the statute.
If we adopt the rules consistent with the statute, do you think that litigants would be precluded from raising any separation of powers issues down the line?
Yes, Your Honor. I think if there was a rule on point, they would no longer be able to challenge the rule as a separation of powers violation, because this court then would have adopted a rule. So regardless of whether it's substantive or procedural, you have a statute and a rule guaranteeing that rule governs. So, and I think that's the approach the court has taken with the evidence code. The court has noted that rules of evidence might be procedural, might be substantive, depending on the rule. Rather than litigate that rule by rule, the court, as a general matter, has adopted the evidence code into its rules just to avoid that issue. And then lastly, I'll just point out that this court also has historically recognized the legislature's role even in matters of procedure. So, for example, the Constitution does give the legislature the authority to repeal rules of procedure by 2/3 vote, which that threshold was met in this case. This statute passed by overwhelming majorities in both houses. So our view is, to the extent that it's inconsistent, the court's rules have actually been repealed. Now, that doesn't necessarily give the legislature the authority to replace the rules, but the legislature adopted this statute out of concerns for public safety, things that go beyond just general courtroom administration. And the legislature represents the people, so we think the court should give their judgment considerable weight.
But there's is there a precedent that treats a 2/3 adopted law as counting as a repeal, or you're just saying sort of as a matter of principle that we should?
So I don't know that I assume you're talking about a statute that does not expressly repeal a rule. I think the closest we would have is in this, the case Delisle v. Crane, the court that had to do with whether to adopt the Daubert standard. The court decided that the statute in that case, which was not an express repeal, did not repeal the court's rule, but in order to get to that determination, the court looked at the vote count and decided that they hadn't met the threshold. So the court didn't indicate at all that there had to be some sort of magic words requirement or express repeal. That as long as the statute is inconsistent with the rules and meets the threshold, that we think that's sufficient to constitute a repeal. If there are no further questions, thank you.
Thank you.
May it please the court. My name is Robert Porter, and I represent the Florida Public Defender Association. Collectively, we represent 19 elected public defenders, as well as hundreds of assistant public defenders and support staff, and we respectfully urge this court not to adopt the committee's proposed amendments because they will materially harm defendants who are presumed to be innocent. I'll be using my time today to discuss proposed subsections I and L, which would allow a pretrial detention order to be based entirely on hearsay and explicitly states that there's no right to confrontation in pretrial detention hearings. We feel this would be unwise for a number of reasons. First, rather than clearing up inconsistencies between the rule and the statute, it would create an internal inconsistency within the rule. Proposed subsection H provides defendants with the right to cross-examine witnesses in pretrial detention hearings, but proposed subsection I would explicitly state that there is no right to confrontation. At the very least, this would subject trial judges and appellate courts to additional legal challenges that were intended to be prevented by these proposed amendments.
But isn't it just the case that if hearsay evidence is admissible, one thing that is baked into that statement is the absence of certain confrontation protections? Hearsay is by definition testimony or evidence that doesn't get subject to cross-examination. If it were truly subject to confrontation, it wouldn't be hearsay.
That's correct. I'm just pointing out that the rule does provide this right to cross-examine.
But the Sixth Amendment right is a trial right. It's not a right that attaches at first appearance. It doesn't attach in pretrial proceedings. And you started out by talking about the presumption of innocence. It doesn't go to the presumption of innocence. That's just not our law. We have a proof evident presumption great provision in the bond statute as well, or the bond rules as well, that tells us that what attaches at this point, the determination at this point, is whether there's probable cause to support the charges, and then with respect to whether a defendant should be detained, whether there can be a showing about danger to the community or risk of flight. I mean, I don't see the constitutional dimension to this that you seem to be suggesting there is.
Well, I'm just pointing out the internal inconsistency within the rule. Where there is a right to cross-examination, it's more or less a catch-22.
But isn't it appropriately qualified so there's not a conflict if it limits, it doesn't limit, just says that there's defendant is entitled to cross-examine witnesses who testify at the detention hearing. Why isn't that sufficiently qualified to where if, in subsection I, hearsay evidence is introduced, that's kind of a different category of evidence?
It is, but if we allow a right to cross-examination, but at the same time allow a police report for the state to meet the burden based on just a police report, it's really an empty right to cross-examine witnesses if there are no witnesses, is what I'm trying to point out. But I also want to get to the hearsay aspect of this and the expansion of the rule beyond the statute. The statute only allows the use of just hearsay to prove these pretrial detention orders for the most serious dangerous crimes, those being capital felonies, life felonies, and felonies of the first degree, where the rule would change that to any dangerous crime. And that could even include misdemeanors. For example, the crime of stalking is both a misdemeanor and a dangerous crime under the pretrial detention statute. And if this proposed rule were to be adopted, a defendant could be charged with misdemeanor stalking and be detained indefinitely based on nothing more than a police report containing hearsay that's often multiple layers of hearsay, double or even triple hearsay, without any of those witnesses being actually presented. And as you may have gathered, this creates another conflict between the rule and the statute that subjects this to even more litigation in the future. And I'd see I've run out of time. Thank you for your time.
Thank you.
Hi, everybody. Good morning. Mr. Chief Justice, Justice of the Court. May it please the Court. My name is Laura Ward. I am a Circuit Court Judge in Hillsborough County. It is my honor to be here today to appear on behalf of the Criminal Procedure Rules Committee. In addition to my committee work, I have been a felony division judge for nearly 7 years, hearing exclusively felony cases all day long, every day. And after that, I served as the presiding judge in our pretrial detention division, which in our circuit is combined with first appearance, and it's where nearly all of the pretrial detention motions for our circuit, those cases are heard. So having firsthand experience in navigating 907.041 from a judge's perspective, I appreciate the opportunity to be here today. I know you all have read the Criminal Procedure Rules Committee comments, so I won't rehash everything here in detail, but what I really wanted to highlight today was our committee's discussion regarding the need for guidance relating to the mandatory shall be filed language in 907.0415D. This provision has created serious practical challenges for those of us who have to work with this statute on a daily basis. Many state attorneys take the position now that they do not have the discretion to refrain from filing pretrial detention motions. As things stand right now, there are many unnecessary pretrial detention motions filed, resulting in many unnecessary hearings being held. And specifically what I'm referencing here are cases where individuals are already being held at no bond, either because they have a pending violation of probation status or because they have charges with charges pending and have already had their bond revoked pursuant to section 903.0471 Florida statutes. In other words, these defendants, and there are many of them, cannot get out of jail anyway. So there's no practical need for a pretrial detention hearing pursuant to this new statute in these situations. It's important to note, as some of the others have alluded, pretrial detention hearings can be lengthy and sometimes complex. Even in the simplest pretrial detention hearing case, testimony is often required from law enforcement and lay witnesses and victims, where criminal defendants pose no harm or risk to the community.
But Judge, aren't we bound by the legislature's choice here? I mean, it sounds like they balanced these efficiencies and inefficiencies and spoke pretty clearly in 9070415D. On what authority do we say that's not really what it means?
Well, so I think the issue that we have here is the Criminal Court Steering Committee proposal now is silent to the shall, what the court shall do and what the state shall do. And the issue with that is, so we're left with the shall language in the statute, and a lot of these things really don't go to the aim of the statute, which is protecting the community, because these folks aren't going to get out.
But that seems to me to be a legislative judgment.
But so I think there are some practical solutions, either by commenting in the rule or by stating in the rule that there's some prosecutorial discretion or judicial discretion. So maybe the practical thing to do is to say, under the statute, sure, the state has to file the motion. They shall file it in all of these cases. But then, and maybe the steering committee does this in 3.132E in the provision for continuances, where a case can be continued where the parties otherwise agree. But I think by sidestepping this major issue, which is these cases, these category of cases that they're not going anywhere. They're in on no bond. If that status changes, then we can address the revocation or the pretrial detention. I think by sidestepping and skirting that, we're not giving the people in the weeds, in the trenches every day, the guidance that they need and the discretion, particularly that the trial judges ought to be able to authorize or exercise, which is, let's make the state file the motion because that's what the statute says, but then let's, in a comment to the rule or someplace else in the rule, let's implement some judicial discretion as to when the hearing has to be had. And so maybe that's the continuance language, but also practically, I think, just saying something like, trial judges could exercise discretion to hold off on these hearings until and unless the motion is actually necessary to keep the defendant in custody. Anecdotally, this is a situation. In Hillsborough County in 2024, we had 900 pretrial detention hearings. Okay, and this is taxpayer money. It is resources from all of the governmental agencies, the state attorney's office, the public defender's office, law enforcement. In our circuit, the state and the PDs have had to hire new personnel just to deal with the pretrial detention. So it's, you know, there are some, I think, some guidance that's needed, whether it be in the comment from the rule or in some other fashion, and that's what
Judge, can I ask a question? Just
Yes.
to make sure I understand.
Yes.
So essentially what you're asking is, in a situation where there is no need to consider pretrial detention because for some other reason they are not getting out of jail prior to trial, that really the statute doesn't even doesn't even apply.
Right.
Essentially, because they're not even subject to being released.
Right, and there absolutely no risk of harm to the community because they're not going anywhere. Right. So they ought to be excerpted out in some fashion. And I think, when we incorporate the rules and adopt the rules or change the rules, we do need to mirror the statute. But I think we can also do that and give some guidance and some help so that these totally unnecessary cases are removed and not an overburden.
You've made reference repeatedly to the continuance provision. That would be by agreement of both sides. Is that correct?
Right. And so
what's wrong with that? Why doesn't that do it?
And maybe it does, but I think what...
Well, but no, okay. I'm asking why it doesn't. If you think it doesn't, why doesn't it?
It only does if you have reasonable and rational players on all sides. Because the language of that continuance...
So whose irrationality, whose irrationality do you expect would interfere with that working?
I think it depends on the jurisdiction. It depends on who the state attorney is. It depends on who the public defender is. And it depends on the reasonableness of all involved. If we could
irrationality is randomly distributed.
Right. Apparently there's no test for it. But if you just could say, okay, we agree, everybody agrees that we're going to continue this matter because the defendant is in on no bond. And when that status changes, we'll revisit it. Then maybe that continuance language gets you there, but I'm just worried that it might not in all cases. And I'm way over my time, and you all have been wonderful. Thank you so much.
Thank you.
Thank you. Just have one or two observations.
Can you start with that last? Can you start with that last issue?
I mean, the committee essentially believed that it would be best to just simply parrot the requirements of the statute, and that's what we've done. The statute does require the hearing, and that's our primary reason for keeping it in. I don't know if I have any other comment to Judge Ward's concerns other than what we've already written in the report.
And the statute requires the filing of the motion and the hearing, or just the filing of the motion?
It requires the filing of the motion and it requires a hearing. And we do, the rule explicitly states that the hearing is required. It doesn't say anything about filing of a motion because of some concerns that we had within the committee.
Yeah, I mean, we really, seems like that would be outside of our
but there is going to be a
anyway.
hearing. And I understand those concerns, but our solution was to simply put in the rule what was required by the statute.
And do you have any thoughts on is there anything beyond just having the continuance option in there the way it's proposed to be in there? Is there anything? I mean, I'm a sort of a commentary skeptic, but I mean, is there?
Yeah, I agree, and I don't think that any other changes would be required to address that.
Can I ask you about the good cause
yes.
standard? So I think that is based on K, right? The division K of the statute. That where a party may motion for pretrial detention to be reconsidered before a defendant's trial if there's information that doesn't exist. Is that what the state doesn't have to show good cause, or is that a different provision?
That is a different provision, Justice. What we're talking about, this arose primarily in a case called Bush out of the First District Court of Appeal in 2011, where what happened in that case, and I'm not saying that this is what the reason we need to have this provision, but what happened in that case is the prosecutor made a mistake at first appearance in failing to seek pretrial detention, and another prosecutor later the same day filed a motion for pretrial detention, and the defendant said, well, wait a minute, that constitutes a modification of bond, and under a different rule, 3.131, the state is required to demonstrate a change in circumstances in order to have a modification. And the First District Court of Appeal agreed with the defendant and said that in that circumstance there has to be a change in circumstance to support pretrial detention. There was a dissent in that case by Judge Ray. The committee was convinced by Judge Ray's dissent that the statute doesn't require any kind of a showing that there be a change in circumstances when seeking pretrial detention at the first instance, but after first appearance. The statute doesn't require it, and the rule doesn't require it, because what it did is use the requirements of a different rule. And there's a qualitative difference between bail and pretrial detention. So we believed that the using Rule 3.131 was not appropriate. So we dispensed with the requirement that there needs to be a change in circumstances, and believe that's consistent with the statute. As far as the contention that hearsay alone shouldn't be sufficient, I'll just note that under State v. Arthur, the court states that the state can meet its burden with affidavits and transcripts. So in an Arthur hearing, it suggests that hearsay alone is sufficient. Moreover, in a violation of release conditions in a revocation of bail, typically hearsay alone is going to be sufficient to support pretrial detention. So essentially, you've just got this narrow lane where hearsay is not sufficient to support pretrial detention. We did not see any particular reason for it. The point of those other cases is that there's nothing inherently wrong with basing a pretrial detention order solely on hearsay, and that's why we say that that's required. And the last thing I'll say is that the right to cross-examination means the right to cross-examine witnesses that may appear at a hearing. It doesn't mean that they have a right to compel witnesses to appear so that they may be cross-examined. So I don't think that those are insufficient. And with that, if you have no other questions, we ask that you approve our proposal. Thank you very much.
Thanks, and thank you very much for all the commenters and the committee's hard work on this. We appreciate it. Curtis, do we have another group coming in? Is there another group coming in? Okay. Okay, our next case is May versus State of Florida, number 2023-1184.
Good morning, Your Honors. May it please the court, my name is William Pinnell, and along with attorneys Eric Cervise and Laura Shapiro, I represent the petitioner Marcus May in this case. I'd like to reserve 5 minutes of my time for rebuttal. At issue today is whether the Fifth and Sixth Amendments to the United States Constitution permit a defendant's minimum sentence of 67 months in prison to be increased to a mandatory sentence of life in prison based solely on findings of fact made by a judge by a preponderance of the evidence. Likewise, pursuant to the PRR statute, can a defendant's maximum sentence be increased based solely on findings of fact made by a judge by preponderance of the evidence?
Can I ask you this? What was the maximum sentence that the defendant was exposed to without the PRR finding?
The maximum sentence was life in prison.
Okay, so we got the same maximum. One's a mandatory under the PRR, but he was exposed to the life sentence without the finding. I understand.
So I would suggest that it's
That's correct. I'm understanding that correctly. So he's exposed to life either way, with or without the finding.
So I would suggest that the life sentence after the PR is a higher mandatory sentence because subsection B of the statute, 775-0829B, specifically says that a defendant will not be eligible for parole, controlled release, or any form of early release. Then they must serve 100% of the court-imposed statute. So if there was another statute that gave someone with a life sentence the ability to have early release, this would preclude it. So it is, in our position,
do we know that there was any such applicable provision that would have, which the defendant here would have been eligible?
I'm not aware of any, but if there was another statute.
Well, if you were aware of one, if there was one, you'd probably be aware of it, wouldn't you?
I would hope so.
Okay. So really none of that affects the defendant here.
I think when we're talking about constitutionality of the statute on its face, I think we need to address whether the statute at issue also increases the maximum sentence. For example, on an F1, a first-degree felony, we would have a...
Well, the constitutionality of the statute on its face, that's an issue here. Obviously, that's kind of the issue that brought it to us. But that's kind of gone away to a significant extent because the state's now conceding that this recent U.S. Supreme Court case has decided that adversely to the position of the state previously, okay? But we've got other issues here because this is in the post-conviction context, which were not developed here. So I'm just, but I understand it's just as this is an interesting context for this issue to come up in, and the kind of the lay of the land's been changed on the underlying issue because of this recent U.S. Supreme Court case, which the state has conceded on. But there's some other issues that might get in the way of relief coming to your client.
I understand, and it's our position that the court is correct and the state is correct to concede that the U.S. Supreme Court and the decisions of this court established in our position that the statute's unconstitutional on its face.
Can you address just the cognizability of this error in the context of 3800A? So we have Martinez and we have Plott. The state points to Martinez because a lien errors, at least in Hughes, for example, classified as a process error. We have Plott, which it doesn't directly address head-on how to square a lien error as a process error with the rest of our jurisprudence that suggests that a process error is better suited for a 3850.
So the Martinez case talks about a lack of notice in the information and it being defective, and the Plott case and subsequent cases, including the Robinson case from the first DCA and Judge Eisnagel's recent concurrence in Denson, find that Plott is the appropriate case and it is cognizable under a 3800A motion if you're addressing the substantive issue of whether the judge or the jury made the required findings as opposed to an alleged defect in the information. And I think that's a reasonable line for the court to establish.
How do you harmonize Martinez and Plott?
For the reasons I just said.
Just the notice issue?
It's a notice issue and they find that to be this court found that to be a procedural issue, and the actual substantive apprendi issue where the jury does not make the finding beyond a reasonable doubt has been found to be substantive, and that's the distinction.
So we would have to, because we also have Hughes, and Hughes came up in retroactivity, obviously, but Hughes classifies Apprendi at least as process. Is there a way to square all three of those?
There's not. I think Hughes is wrongly decided, and the court should recede from that based on its decision in Poole. I think if you read Hughes and you read Erlinger, they're inconsistent. Hughes is still talking about sentencing factors and still talking about minimum mandatories being okay. I think that the case law has evolved. The U.S. Supreme Court has more fully explained what Apprendi means, and in light of the significant discussion of the history of the Sixth Amendment and what the framers intended in Erlinger, it's now obvious, in our opinion, that this right is a substantive right that's entitled to retroactive application, and Hughes is outdated given the current.
But none of the U.S. Supreme Court cases find that this is retroactive, right?
I'm sorry?
I mean, is there? Can you point us to a case that said Apprendi is retroactive?
Well, I would point this court to
Erlinger.
There's no. As far as I can tell, there's no cases that have come out since Erlinger was addressed that address the retroactivity of Erlinger. There may be a stray case from out of state or a federal case.
What about Apprendi, Aline?
Well, this court had previously found Apprendi to be not retroactive, but I would point this court to the Mosley decision.
What's the U.S. Supreme Court said about that?
The U.S. Supreme Court has so far said that Apprendi is not retroactive.
Yeah. Okay, they've been saying that quite a while.
So can we kind of go to first principles on this? Because let's say we want some harmony between Plott and Hughes and Martinez.
Sure.
Looks like either Plott or Hughes has to fall to seek harmony, right? You'd agree. So if we start with a legal sentences, we've precluded those that are errors in the process. If this is a sentence that could be imposed legally, it's subject to harmless error, it's subject to preservation. How is that not a process error? So in other words, if the process had been followed, this sentence would be illegal. The process was not followed, therefore it is a sentencing error or an error in the judgment. How do we elevate that to something that we've classified as a legal sentence? In other words, sentences that, under no facts and circumstances would be able to be imposed under the law.
Well, I point to the court's recent decision in a Dettel case where it acknowledges that the Apprendi rule is, quote, in some sense procedural, but also of a substantive character because it addresses what the state must to prove its case, and beyond a reasonable doubt is the standard. So we believe that beyond the reasonable doubt standard is a substantive component, and Dettel provides authority for the fact that this is a substantive rule.
But that wasn't argued here. That's not part of this case. That's not what the case was decided on. There's nothing about that. It's all about the finding, not the burden that's on the state. Right? I'm correct in reading May, the opinion in May.
I certainly would agree with Your Honor, because the court didn't get to retroactivity or a remedy because they denied relief. So they said that it was appropriate for the trial judge to make the finding by preponderance of the evidence, based on the Simmons case from the 5th DCA, which held that the statute was constitutional on its face and as applied. So no court in this case has addressed retroactivity. As of this point, it's our position, given the change in landscape that you've discussed, and that.
But I guess go back to, and maybe I'm missing your train of thought here, but the decision in May, the decision on review here, does not address the burden of proof. Isn't that correct? I mean, you're talking about that as using that as something that puts us in some kind of different category, but that's not even talked about here, I don't think. It's all about the factual determinations required to support the PRR designation were made by the judge, not the jury.
So our position is that the May case relies almost entirely on the Simmons decision from the 5th DCA, and the 5th DCA addresses both the jury and judge finding and the beyond a reasonable doubt standard.
How does it rely almost exclusively on Simmons? That's just one case in a string cite, and it's cited for the general proposition that establishing the date of release from prison is simply a ministerial act. Do you see another citation to Simmons?
No, you're correct. The trial judge below relied entirely on Simmons, so I misspoke. The trial judge below said they were bound by Simmons and cited, I believe there's a parenthetical in the trial court's order saying that Simmons found the statute to be constitutional on its face and as applied. It's our point it's our position that once an Apprendi issue is raised, it's readily apparent that both the issue of who makes the decision, the judge or the jury, and what quantum of proof is necessary is implicated. Just because, and we now know, as the state conceded and as Erlinger states, that any kind of enhancement like this needs to be proven to a jury beyond a reasonable doubt.
I'm sorry to interrupt you. Could you try to, and you're getting sort of bounced around here, so it's not totally your fault, but could you please directly respond to Justice Sasso's question about whether, I think part of her question was, is 3800, is that just inconsistent with any type of claim that would have to be reviewed under a harmless error standard?
And with preservation requirements.
Meaning that it's not fundamental error, is that your point? I mean, but start with the harmless error thing, because that seems like the point of the 3800 rule is you're supposed to be able to just look at the face of the paper in front of you, and then you can kind of, it's a yes or no, is it legal or illegal, and there's a remedy. It seems like here you can't do that because of the harmless error issue. And so if one of the things that's floating around here is trying to harmonize, if we have inconsistent precedents and we've got to choose which path kind of makes more sense given the rule and what it's for, if you could just directly respond to the idea that if it's subject to harmless error analysis, that it basically doesn't fit within the 3.800 framework.
Well, I guess I disagree. So under plot, the remedy in plot was to remand to the DCA to conduct a harmless error analysis, and then once they determined that the error not to be harmless, to remand the case for resentencing.
Is there any other illegal sentence that you can think of that's subject to harmless error analysis? I haven't been able to think of one.
Not as I'm sitting here, but I will think of one for rebuttal.
What prevents this from being more appropriately a 3850?
It's an illegal sentence that clearly contradicts constitutional provisions, and the long-standing tradition of this court and precedent of this court it is something that can be determined by reviewing the court file.
But if
you don't need to be evidence or testimony.
If there was harmless error, is it really an illegal sentence?
Well, first of all, we don't think harmless error analysis is appropriate if the statute's unconstitutional on its face. We think the statute should be voided in its entirety, and then there is no harmless error review. The statute does not exist then, and he should be sentenced pursuant to the Criminal Punishment Code. So I think that's the most straightforward and the correct answer. Apprendi errors
I don't think we've handled that in similar context in that way. I mean, I think there's a lot of precedent, or at least some precedents that would defeat that argument, because this is one context, but these issues about what the judge has to do as opposed to the jury's come up elsewhere, and we have not decided those cases in a way that's consistent with what you're saying, I don't think.
So if the statute's unconstitutional on its face because it requires the court to make the decision and the decision to be made by a preponderance, the statute's unconstitutional on its face, and like this court did in Heggs, it should invalidate the statute and then require resentencing according to the valid statutes that remain.
If there's a constitutional error, but why in a case where evidence was admitted, it's beyond a reasonable doubt that any jury that would have considered that evidence would have found the defendant to be a PRR under the appropriate
Because
standard
if
of
there's
proof.
no, go ahead, I'm sorry.
Yeah, so I mean, that is harmless error analysis.
I understand, but I don't think harmless error analysis applies if the statute is unconstitutional as applied. And I point the court to Judge Maker's concurrence in the Woods decision, where he says the whole statute should fall. And
Well, in terms of remedy, but that, I think harmless error and remedy are different.
well, I guess
If it's not harmless error, then you got to go to remedy. And then
I'm having a tough time understanding if the statute is unconstitutional and cannot be applied constitutionally in any manner. Why we
well, the harm of an unconstitutional statute is an unconstitutional sentence because of a constitutional error. It's not the fact that an unconstitutional statute exists, right? There has to be some harm. And if that error is harmless because the protections that are afforded by the Constitution were in fact honored in that case from a factual standpoint, I don't understand.
So it's our position that the statute compels, the statute requires an apprendi error because it requires preponderance of the evidence and requires the judge to make the decision. So there's no constitutional way to apply that, and the only remedy for that is not to.
Well, but there is a constitutional way to apply it. The statute is subject to the requirements of the Constitution. If the burden of proof in the statute is wrong, we apply the constitutionally required burden of proof. That seems to be a simple way to solve the issue without causing a disruption in the whole system of justice.
So I don't think the remedy is to violate the separation of powers and rewrite the statute, and that's what the court is suggesting.
It's not rewriting the statute. It is causing the statute to conform to the requirements of the Constitution rather than disrupting the system. But again, you have your position, and But I don't think it's consistent with our precedent.
Well, Can I ask you a related question about that?
Is it 3 minutes?
Go ahead. Go ahead.
Entire time left, or
we'll give you more time.
Okay.
Could you respond to the state's argument that really the only facial problem with the statute is the burden of proof, that it doesn't? I understand that it's it has been applied. Apparently, it's been applied as the judge making the decision, but the statute doesn't explicitly say that the judge is the one who should be making the decision.
I think a fair reading of the statute makes it clear. It's a subsection 3 of 775-082-9A3 says, if the state attorney determines that the defendant is PRR, the state attorney may seek to have the court sentence the defendant as a prison release offender. Upon proof from the state attorney that establishes by a preponderance of the evidence, the resulting sentences apply. I think when you put those two sentences together, it's readily apparent that the legislator intended that a judge make the finding.
But if we wanted to read, let's say that it didn't have the burden, the standard of proof problem, and we have all the canons about trying to read things as being constitutional. I mean, obviously the judge is going to be the one sentencing, but it doesn't on its face say who has to make the finding.
Well, I respectfully disagree. I think that the way it reads, it indicates it should be the court. We know that the legislature knows how to say when they want the jury to make the finding. They've done that in the capital sentencing scheme, pre-Hearst and post-Hearst. Pre-Hearst, they said the jury made recommendations, and they used the word jury in the statute. And post-Hearst, they lay out what findings the jury has to make. And the word jury appears, not solely the word court. So I think it's reasonable to conclude that the statute as written requires the judge to make the finding. Back to Justice Kennedy's question, Menango, in Justice Lawson's opinion, talks about the court's ability to effectuate remedies and imply and they changed the burden of proof, and they changed from the judge to the jury in that case. What he says, and the court says in that case, that that's a rare occurrence, and there's a separation of powers issue. And I think, and he says that should only be used when we're addressing, quote, new problems that the legislator has not had time to react to. This isn't a new problem.
Well,
Apprendi was decided 24 years ago.
How old is the statute that your client was sentenced under?
It's from 1997.
Okay, so, but we're talking about that statute, 97, the 97 statute. That's what's at issue in this case, correct?
Correct, and it's not a new problem.
Well,
so the standard that Justice Lawson indicated was...
But it's got to be what you would have expected the legislature to do in 97, not now.
Well, In the Monego case, in a footnote, the court also says that the legislator is on notice of Supreme Court precedent.
Well, but here it's Erlinger is the relevant precedent, right?
I disagree. I think the relevant precedent starts with Apprendi.
The Supreme Court itself doesn't even agree internally about the whole prior conviction thing, and this is just sort of a subsidiary issue, aspect of that.
Actually, they do agree. They say in Erlinger that they've discussed how narrow that exception is. It's the bare fact of a prior conviction, and they say we've said this to the point of, quote, downright tedium, and they lay out from Apprendi to Ring to Alany all the way through to Erlinger. So there is an internal inconsistency. The internal inconsistency is whether that exception should be destroyed completely and removed completely. They are 100% in lockstep.
Well, three of them would disagree.
Okay. So the majority is in lockstep that since Apprendi, they have clearly delineated this is a narrow exception that only applies to the fact of a prior conviction, not a related fact, not a ministerial fact, not something that's a derivative fact. It's only the fact of the prior conviction. And the reason for that is simple, is because that prior conviction has already been subject to proof beyond a reasonable doubt and a finding of a jury. So you already have the protections that the Constitution requires.
Okay, you can have 30 seconds to finish up.
So it's our position that the statute is unconstitutional on its face, that the sole remedy is to remand for resentencing pursuant to the Criminal Punishment Code, because that would remain intact. The PRR statute would not.
Okay, thanks. And you can add 3 minutes for rebuttal. Thanks.
Mr. Chief Justice, and may it please the court, at the outset, we view it as a bit of an inconvenient truth that the court lacks jurisdiction in this case. Now, that hasn't come up today, but that is our view.
Yeah, let's talk about that.
Yeah.
So let's hear your spiel on that.
Sure. So I'm sensing some skepticism then.
No, I mean, before we ask questions, I mean, you have the floor,
yes.
So let's hear it.
Certainly. So let me say, first, we're actually quite eager to get answers on a couple of the merits questions in this case, in particular, the propriety of doing 3 decades after the fact, and also the retroactivity point. But the reason that we've raised the jurisdictional point is because, post-1980, the court's jurisdiction over express declaration cases has to turn on a district court decision that actually expresses the view that the statute itself is constitutional. Now, the lower court could have done that here if it had acknowledged that there is a provision of the PRR Act, sub 9A3.
Let's just engage with the text of the decision below.
Sure.
May argues, as he did in the trial court proceeding, that his life sentence as a prison release reoffender is unconstitutional. We reject this argument because the date a defendant was released from prison or jail and the nature of the qualifying offense are ministerial in nature and thus do not require jury findings. If the court expressly rejects an argument that the statute or the sentence pursuant to the statute is unconstitutional, how can the law be anything else in this district that the statute is constitutional? I mean, if you were a practitioner in the 6th DCA, how would you get around this case in arguing that the statute was unconstitutional?
Yeah, I think it would be difficult, but I think that argument sounds in the old inherency doctrine. So just to give you an example, there are sentencing enhancement statutes. The 1020 life statute under 775087 is one of them that implicates Apprendi only insofar as what the judge does at trial. There's no actual legislative text that says, here's the burden of proof, here's which decision maker.
And that could be the case, but I think when you read it in context, and so I guess my concern is that I'm concerned that your argument is a magic words argument, because the court clearly did not reject that here. The court categorically rejected the unconstitutional sentence argument because of this ministerial exception. To me, that's a statement that I understand it's a different constitutional argument than you think is the constitutional infirmity with the statute, but it is still a decision by this court that the statute is constitutional for the reason that they were caught up on.
I think at the end of the day, downstream, it has the effect in a roundabout way of saying that there's not a constitutional defect with the statute, but the constitutional defect is in a provision of the statute that is not cited, it's not quoted, it's not otherwise referenced. And so the reason that I brought up the 1020 life statute is because if a similar challenge, the DCA could have said the identical thing about the 1020 life statute, subbing in instead of the PRR release date finding, whether a weapon was carried or used in the commission of the crime, but that wouldn't actually implicate the statute itself, because there's nothing in that statute that violates Allain and Apprendi. It's what the trial judge does in a case like that that implicates the Sixth Amendment. So for all you know, looking at the four corners of this opinion, which is what you do when you review your jurisdiction, that's what happened in this case. But again, I don't want to die on this hill.
Have we ever said that the four corners, and I understand that's an important principle when there's issues about facts that aren't, when we're looking for conflicts and everything, but when the court explicitly says that we agree with the reasoning of such and such case and then cites it and has the parenthetical, do you think that we should apply the four corners so strictly that we wouldn't even give the court the benefit of essentially incorporating the reasoning that it's saying that it agrees with?
Chief Justice Muniz, I think the rule that we laid out is that if you have to draw some inferences about what the district court thought about the statute itself by resorting to, say, reading the Simmons case, which is cited in the opinion, I think that goes beyond
Tell you what, Mr. Solicitor General, if you promise never to cite this case in the 6th District on behalf of the state for the proposition that the statute is constitutional, then we'll take this jurisdictional argument more seriously. But I have a feeling that this is the first case you would cite the next time someone made the same claim in the 6th. You would say, this court has already found this statute to be constitutional, see May.
Well, we obviously
he's admitting that they're wrong.
Right. So, but as I've said, I don't want to die on this hill. We just feel as though we have to make this argument because we want to be fair dealers with the court about the scope of its jurisdiction.
Mr. Justice, I have a question for you. All right. So assume we all agree that we have jurisdiction. We're going to exercise the jurisdiction. Why should we not grant the relief as requested by the appellant?
Sure. So I'll start with the 3800A bar here. There have been a lot of questions about, say, how to harmonize the plot case with some of the court's other decisions. I think that's very hard to do, but I give you a sort of narrow path to that result that wouldn't require overruling plot in a future case. But Justice Sasso, to your point about is it just Hughes that would have to be overruled, it's actually not just Hughes. It's every time this court has done a retroactivity analysis in an Apprendi progeny case, it has effectively held that it's not Apprendi is not a substantive rule. So because in all of these cases, including Mosley, the court is looking at the second prong of the Witt test. The first prong is, well, is it a substantive rule? And the court has never found that it was a substantive rule. It didn't place beyond the power of the state the ability to impose the punishment. It's always done it on fundamental significance, which is a finding that Apprendi is a rule of procedure, which is precisely what the U.S. Supreme Court said in Truro versus Summerlin. So you'd really have to be overruling all of those cases, and there's no good reason.
Overruling all those to keep plot.
To keep plot, right. Precisely.
Or what if plot was considered not the best route, and we looked at a different route for these errors to be brought, such as 3850?
Yeah, I think that's exactly the route that the court should go. I think that's the most principled way to look at this. I would offer one caveat on the 3850 point, which is that we have held out 3850 as the appropriate procedural mechanism for raising these in post-conviction, but we still believe that there needs to be a contemporaneous objection at trial. The third DCA has recognized that in a case called Lutton, and I think that makes all the sense in the world, because otherwise you permit a defendant not one jury trial, but really two jury trials. A defendant can sandbag the state in the trial court by sitting silent at trial, not requesting a jury finding as to the disputed element, which may not even be disputed, and then later impose additional procedural hurdles on the state and the need to re-impanel a jury. So we think that defendants should be objecting contemporaneously when this comes up. Now, if you don't have to say, by the way, that plot is incorrect to get to our result in this case. There is this way to distinguish plot, which is that, although I think it's incorrect because plot should have just said what Martinez said, which is that this is procedural. You can't raise an age-old procedural claim with 3000A. But at least that case dealt with Blakely, which dealt with the statutory maximum. So this court has sometimes said that a sentence in excess of the statutory maximum is illegal. And,
in a sense,
And I understand that from the brief, but I have a hard time accepting that that would create any sort of coherency when an Alene error is an Apprendi error according to the United States Supreme Court because it increases the penalty. So it would just seem to be splicing for the purpose of keeping a case and still maintaining the
Well, look, I
inconsistency.
think that's right. I mean, I think that's totally right. The most principled view is that plot is incorrect. But, you know, if the court wanted to, it could say, look, we don't have to take that on here because it's a little bit of a different matter, and you could sort of get to the right answer without having to overrule.
I've never seen this level of wizardry applied by your office to try to get us to keep one of our precedents. It's usually just, you know, recede.
Well, there may be a future case where we put that question to you, a future Apprendi case. We just don't think it's necessary here.
Can I ask you to respond to the argument just on the issue of whether, assuming plot doesn't exist, whether or not an Alene error should be cognizable as a legal sentence? I think the argument is that it's a vindication of a substantive constitutional right. For that reason, it's substantive and shouldn't be processed for purpose of a legal sentence.
So we think that that's just incorrect, and the precedents say that that's incorrect, including Schwiro from the U.S. Supreme Court. So the dichotomy here in the criminal context, something is substantive if it takes away, a rule is substantive if it bans the state from imposing liability or imposing a particular penalty. Everything else is procedure. So the steps along the way, including, you know, this court has said in Hughes and the Supreme Court has said, deciding which decision maker has to make a factual finding, that's all procedural. So under that, you know, that very old, well-settled dichotomy, I think that this is a rather easy case on whether it's substantive or procedural. Now, I know that there's some language in Dettel that's dicta that describes Mosley and says that, well, you know, Hearst is in some sense substantive, but I think that that is, you know, that was not the question in the Dettel case, and I think looking more broadly at the court's precedents, it's clear that this is, you know, procedural in the relevant sense. Now, the reason that we think Martinez draws a good line between substance and procedure you can't do with 3800A, substance you can, is because 3800A, when the court drafted that rule, it was sort of looking at a compromise between, on the one hand, fairness to defendants. We don't want you serving time for an illegal sentence, but also respecting the state's critical finality interests. And this case sort of lays bare the problem for us, because it's 2 decades later, the defendant is coming here and he's saying, I have a problem with the procedure used back in 2003, and as a result, I want an entirely new full de novo resentencing. Now, that is going to be very difficult for the states to do, not necessarily because we have to prove the PRR fact, that's ministerial, that's pretty easy, but we would potentially have to recreate for the judge the facts of the crime. We may not have witnesses available, we may not have documents available, and not just that, if 3800A can be used in this manner, it's not just Mr. May's case and a handful of other cases, it's the 7,100 Florida inmates currently serving time under PRR minimum mandatory sentences, and perhaps some other sentences. So we would have to retry, you know, all of those if you're not doing harm review and you're allowing these to be raised under 3800A.
Even under 3800A, there is harmless error review. I mean, we've said that.
Yeah, so what you said in plot was remand to the district court to do fundamental error review. There's sort of a question after Monago about whether a trial court could do harmless error review under 3800A. We think they probably can because they're sitting in review of what a prior court did. But in Monago, you know, the court did say that a trial court, at least in the sort of direct appeal, you know, resentencing context, could not do its own harm review. But I think we trust that the trial court could here. But still, I mean, we're talking about 7,100 cases flooding the system where judges have to expend their
if there's
resources.
a constitutional error, there'd be a constitutional error. And I don't know if we could ignore, you know, a constitutionally required remedy just because the bulk of defendants that it would affect. But on harmless error, I asked your friend on the other side if he could think of any other illegal sentences that were subject to harmless error review. I have the same question for you.
So it's possible. I'd want to spend some more time thinking about that. But you could imagine a case where there's a you know, there's a min-man imposed by the statute, and so the judge didn't have to sort of like think too hard about what sentence he or she was going to impose for that defendant. It had to be 15 years. And so you're taking that off the table, and then there's potentially a remand, but it may have been that the judge had the judge had to grapple with that sentence would have said that 15 was appropriate anyways. So you might even have to do harm review like in a circumstance like this. So it's not, I don't even think it's quite as simple as my friend is suggesting that, well, you wouldn't even do harm review if this statute was facially unconstitutional in all respects and couldn't be applied at all. So even if he could get past the severability hurdle, harm might still apply, because it could have been that this judge would have looked at this and said, of course I'm giving you a life sentence, which he could have, without the min-man.
But just to clarify Justice Sasso's question, there's no other thing where we've said or indicated that under a 3.800A illegal sentence analysis there is harmless error review.
Yeah, Justice Grosshans, I'm not aware of that. They all tend to be things that it's pretty clear cut. You exceeded the stat max. You couldn't have resentenced in violation of double jeopardy. Things where the error is structural. So I think that as a rule probably makes a lot of sense, because, and the reason that I was offering the point about the 7,100 inmates is when the court adopted the rule, I think it sort of had this situation in mind, the protection of the state's finality interests. So the court did away with the 2-year statute of limitations, or didn't insist on a limitations period like in 3850, but the trade-off is you have a very narrow definition of an illegal sentence. Are there any additional questions that I can answer? Thank you for your time.
Thank you.
May it please the court. Initially, I think it's unfair to talk about the 20 years later. I think this rule has been clear since Apprendi and the legislature and the courts have been slow to address it. So I don't think that should be held against a criminal defendant when the right was recognized in the year 2000, and here we are in 2025, finally applying it correctly, and the U.S. Supreme Court is essentially telling the entire country, we've said this over and over again, the downright tedium, and you guys aren't getting it. So I don't think it's fair to put the delay onto the defendant. Additionally, the retroactivity issue, Mosley explicitly says, as a matter of fundamental fairness and an application of the Witt test, that they're going to apply Hearst retroactively, and they apply it since Ring from 2002, when Ring initially would have rendered the Florida statute unconstitutional if the Florida Supreme Court had acted appropriately, or if someone had made a decision. But they said, as of 2002, the statute was unconstitutional. So our position is, as of 2000, the statute was unconstitutional. And Mosley specifically applies a right to a trial by jury, Sixth Amendment claim, retroactively. So there's a conflict between Mosley and the case we discussed earlier. And I would suggest that Mosley is more in keeping with the current opinion of the U.S. Supreme Court in Erlinger. And the Dettel case explicitly says it's comparing a double jeopardy analysis on appeal, and it says that's not retroactive because that's a procedural mechanism by the appellate court. It compares it to the right to a jury trial, and they say that that has a substantive character because it talks about what the state must do to prove its case beyond a reasonable doubt. So again, it's our position, the statute's unconstitutional on its face. You don't do harmless error review if the statute's invalid. It's just invalid. It doesn't apply. You then return to the statutes that are the valid statutes that remain, and the state's correct that the judge could impose a life sentence, but he gets de novo sentencing pursuant to the Criminal Punishment Code because the PRR statute says he doesn't get a sentence pursuant to the guidelines. Now he gets a sentence, and the judge gets to exercise his discretion to impose a sentence between 67 months and life. So the judge then gets to decide whether this particular defendant, his conduct and his history and characteristics justifies a life sentence or something smaller. So, but we think the clear indication of Erlinger, it's our position that Erlinger actually says that this is what the Sixth Amendment meant from the time it was enacted. So we would suggest it should go back to everyone, but at the very least, to Apprendi when this right was explicitly recognized by the U.S. Supreme Court. Thank you.
Thank you. We'll be in recess for 10 minutes.
All rise.
All rise. Florida Supreme Court is now in session. Please be seated.
Okay, our third case is Woodbury versus State of Florida and Woodbury versus Secretary Department of Corrections, numbers 2024-0232 and 2024-1127.
May it please the court. My name is Mari Louise Parmer, and I'm here on behalf of Mr. Woodbury. I would like to focus my argument this morning on the claim raised in my state habeas regarding the unconstitutional shackling throughout Mr. Woodbury's trial. The record is clear that Mr. Woodbury was fully shackled from hand to...
But I don't want to jump too much ahead of you here, but I mean, just kind of cut to the heart of this. Isn't the record equally clear that he was given a choice of the handcuffs or a stun belt?
Yes.
And that the judge explained to him repeatedly and at great length that he really didn't have to worry about it because he'd never seen the stun belt used, and that it was going to, the shackles would be a bit of an issue for him, and really the trial court really tried to urge him not to have the shackles, but he wanted the shackles because the idea of the stun belt didn't appeal to him. So I just, this is not, it's a choice he made. So tell me why we wouldn't look at it that way.
Well, you're correct in that it was ultimately a choice that he made, but that's not the starting point. Because number one, the United States Supreme Court has held clearly for a number of years that it is unconstitutional to shackle a criminal defendant either in the guilt phase or the penalty phase of a capital trial. So number one, that's wrong. Number two, this court, in its own opinion in, sorry, give me just a moment. Weaver held that a stun belt is equivalent to shackling. And we know from DEC that before a trial judge shackles a criminal defendant, they have to hold a hearing, an individualized hearing. None of that happened here.
Well, there was an objection.
There was an objection, Your Honor.
And so constitutional rights can be waived. There was no objection here.
No, there was an objection, Your Honor.
Okay, so how do you classify what he said as an objection?
Because this court has said that, first off, what he said, to make it clear, he said the way this transpired is that the trial judge encouraged Mr. Woodbury to wear jail garb, which indeed in and of itself is unconstitutional. And then Mr. Woodbury said, okay, I'll wear my prison outfit. And then, but I don't want to wear these. I want to have my hands free. And the court says, well, I agree, you should have your hands free. So that is an objection. And the reason that is an objection is because this court has said that, if you give me just a moment. I want to make sure I get the quote right. No magic words in Figueroa versus Sanabria just last year, this court. All of you were on this court at that time.
So we know there's no magic words, but can you help me understand this part of the record? And I know we just addressed it on May 4th, but just for the record, Mr. Woodbury is wearing a blue prison uniform and he requested handcuffs and shackles, which he requested. Is that still your request, Mr. Woodbury, or would you like to be dressed different? This is excellent.
No,
This is excellent.
that's not the hearing. That's later in the trial. That's when he's in front of the jury, when he's doing jury selection. So the actual, if in my initial...
Isn't that the constitutional implication?
I'm sorry?
Isn't being in front of the jury when the Constitution's implicated?
The Constitution's implicated when he's in front of the jury, but what I'm trying to clarify for the court is that that's a different time when that is mentioned. So in my brief, I've set out if the full quote and the full series of events of how he becomes shackled. So the part that Your Honor is quoting, which is an accurate quote in the record, comes later. He's already acquiesced to the shackles. And so what I want to make clear, he has objected. He objected. This court has said no magic words are required to make a proper objection. Florida Statute 924.051.
Okay, I understand that don't have to be magic words, but there have to be some words, okay?
There were. He said, I don't want to be shackled. I don't want these. And the court says...
And the court said you don't have to be. The court, and so it seems like what you're arguing is that he shouldn't have had the Sun Belt either. But he didn't object to that. There was no objection to the Sun Belt. Or to the option of a stun belt. There was never anything that told the judge that I should not be restrained in any way, and I object to any restraint. Nothing. If you can point me to anything like that,
Your Honor, he objected to being shackled at his wrists. He made that objection. He's a pro se defendant. Just like this court has said, pro se defendants have choices and they run the risk of their ultimate choices. But you know who else has a choice, Your Honor? The trial judge. And the trial judge is trained to know the law. And the trial judge misled Mr. Woodbury about the law, because what the trial judge said is, I get to decide that, and you can either have a stun belt or shackles. That is not a correct statement of the law, because the law says that the court, before he can give or make Mr. Woodbury wear a stun belt or shackles, he has to hold an individualized hearing. Nothing was done here. There was no individualized hearing.
Well,
Your Honor,
but he didn't ask for one. I mean, again, I understand you say he's a pro se, but he made that bed. He decided to be a pro se, and he's got to perform for himself. He made the choice.
The judge
why he did that, that's up to him. Probably not a wise choice, but it's a choice he made. But you're trying to turn this into something where trying to make the judge here as some kind of bad actor, when I just think the judge was actually going out of his way trying to work through this with the man and give him the options and to be reasonable. Now, the overarching all this is this is a man who comes in here having been charged with most brutally violent, just kind of unspeakable violence. And so the idea that at the end of the day there's not going to be anything done to restrain him appropriately seems to me to be far-fetched.
Your Honor, I respectfully disagree with all of that. And I'd like to address it twofold. First, I'm not indicating that the judge is a bad actor here. What I'm indicating is that trial judges, just like appellate judges and just like lawyers, we're required to follow the law. And trial judges who are trying death penalty cases, we rely on them to know the law as best as they can and to follow the law. That's our foundation of justice. It's a foundation that we all rely on as judges and lawyers and actors in the criminal justice system. And so whether this judge, I'm not suggesting that this judge intentionally misled Mr. Woodbury. I'm saying that this judge misled unintentionally, or whatever his motivation was, but I'm going to assume that he was doing the best that he could and he made a legitimate mistake. I'm not casting aspersions on his character, but he misled Mr. Woodbury about the law. And when Mr. Woodbury objected, Mr. Woodbury isn't supposed to, he's not required to object and say this is a Fifth Amendment due process violation and I demand an evidentiary hearing. That's not what this court has said is the requirement. And when it's a pro se defendant, a judge he's not obligated to make objections for a pro se defendant, but he is obligated and should be obligated to be careful and to follow the law and to construe a pro se defendant's concerns and statements as an objection. And that didn't happen here. There was no hearing that was held. Now, the other point that Your Honor made is that he was charged with unspeakable violence and he was a capital defendant. And that is true. He's a capital defendant on trial for murder. But so was the defendant in DEC. And the requirement that the court follow the law is even more important in cases exactly like this, where the defendant is charged with a heinous crime. Because it's in cases like this where emotions can run high, where failures can happen because of the desire for punishment, rightly so, right? You know, that's part of the criminal justice system. But he was charged, he was charged with unspeakable violence, but what you have here, because the question isn't just what he's charged with, it's how he's going to comport himself in the courtroom and whether or not his behavior requires shackles. And what we know from this record and from this court's opinion on this case in direct appeal is that Mr. Woodbury was the most profoundly well-behaved, respectful, polite, pro se defendant that this trial judge had ever seen.
Well, yes, Mr. Woodbury also basically set off a hostage situation in a penitentiary and only relented when there was a threat of imminent sort of invasion. I think the court has to balance how polite he's being in court with that history in making the decision that it made.
I think that the trial court, is allowed to consider, and what DEC tells us and what the Supreme Court of the United States has told us, is allowed to consider the nature of the charges, but simply because you are a capital defendant doesn't justify shackling in front of a jury.
Okay,
and so
we're
what
sort of
you
talking
have
past
to,
each other. He wasn't simply a capital defendant. The point I was making was he was a capital defendant who took a hostage as part of his crime.
He didn't take a hostage. He killed his cellmate.
Okay, he killed his cellmate
and was a brutal
entry
murder. I'm not here to dispute that, but all capital crimes, by their nature, are supposed to be egregious murders. Otherwise, we shouldn't be seeking the death penalty. And so you can't just stop there. The next step that DEC requires a trial court to honor is a full analysis of the risks of courtroom behavior. And here you have a capital defendant who was unmedicated when he committed his crime, was medicated at the time of his trial, something that this court noted in its direct appeal opinion in justifying the justifying the pro se status. He was medicated and he was well behaved. He was well behaved throughout all of his proceedings. And even if even if the trial court had felt that he needed to be shackled, he didn't need to be shackled in the manner in which he was shackled. And the trial court could have made some effort, just like the trial court did in other cases where this court has addressed shackling. The trial court could have let his hands be free and had him sit behind counsel table and put a skirt around the table so that the jurors couldn't see the shackles. He could have been in belly chain with leg shackles. He had 2 armed bailiffs standing behind him or near him at all times, which is constitutional, which the Supreme Court has said is constitutional. But the trial judge made no effort in this case to conceal the shackles from the jury, simply none. So Mr. Woodbury, as is evident from the brief, there was no admonition to the jury saying you may see Mr. Woodbury in shackles and prison garb. You're not to make any inferences from this, although I don't think
Did he ask for that? I mean, again, you're kind of absolving him of any responsibility to object to the things that happened that you are now complaining about. And that's not the way this process works.
Well, I think, with all due respect, Your Honor, the process isn't supposed to work in a way where the trial court allows a blatant and egregious and gross violation of a pro se defendant's rights. And again, not that the trial court is a bad actor, but he did nothing here. And the trial court, we've seen, I have never in all my years, and I've been doing this a long time, and I've watched this court and argued before this court, and I've never, ever seen a case where a capital defendant appeared in front of a jury in prison garb, fully shackled, walking about the courtroom with no effort.
But he wanted to be in the prison garb.
He only wanted to be in the prison garb because the court suggested it to him. And what's interesting in Estelle being the Supreme Court case, U.S. Supreme Court case, that says that defendants cannot be made to appear in prison garb. What's really interesting about Estelle, if you take a moment to go back and look at it, is that there was a dispute there about whether he was coerced or it was mere acquiescence. In that case, Estelle was represented by counsel, and counsel failed to object, and they had an actual evidentiary hearing in federal court about why counsel failed to object, and there was some testimony about whether it was the usual practice and that whether or not he was afraid to anger the judge by objecting. And ultimately, the court ruled that because his lawyer made no objection, that reversal was not required. But they did talk about what maybe could be compulsion. And I think that what you have here with the prison garb is you have a judge saying, hey, why don't you wear your jail clothes? It's a prison murder. No big deal. I mean, that is literally what the judge said. That's a quote, no big deal. And Mr. Woodbury, pro se, severely mentally ill, which we know even more about his mental illness now in post-conviction than they did at the time of trial. This is a man who was committed to mental hospitals. That Mr. Woodbury says, yeah, okay, I'll wear my jail clothes. That's true, he said that. But he didn't want to be shackled. And he said that very clearly. I don't want these, I don't want to wear these. And the judge says, yeah, I agree with you, your hands should be free, but you have to wear a stun belt. And he said, I don't want to wear a stun belt. But the judge is telling him what the law is. The judge is telling him the law is, I decide, and you either wear a stun belt or you wear shackles. That's a misstatement of the law. And so you can't fault a pro se defendant. He's made his objection, but then you can't fault him for believing the trial judge and who's telling him this is what the law is. And so this is an egregious, this is a unique case. I know this court sees a lot of capital pro se defendants, mentally ill pro se defendants representing themselves, and what should be done about that is an argument for another day. That's not the issue right now. But this is an egregious case where the pro se defendant was made to appear before a jury who's going to decide whether he lives or dies, unconstitutionally shackled and in prison garb, which the Supreme Court of the United States has repeatedly told us is inherently prejudicial. And so the next issue then, I think there's no dispute the extent of the shackling. It was gross and it was egregious. The next step then, of course, is even though this is inherently prejudicial, this court has to engage in a harmless error analysis. And the harmless error analysis in a penalty phase proceeding is different than what this court would look at in guilt phase. And so there was overwhelming evidence of guilt here. That's, I think, I can't stand here and dispute that. But we know that in penalty phase, that jurors have the right to vote for life, even if they think that the aggravators substantially outweigh the mitigators. And we tell them in jury instruction, in the mercy instruction, that you as an individual juror can still render a vote for life. And so when you're thinking about harmless error in this case, I think you have to take that into account, because Mr. Woodbury was tried at a time when unanimity was required. It would have taken but one juror to have mercy on Mr. Woodbury. And so the state cannot prove that this egregious use of shackles is harmless. And so I believe that I'm running out of my time, and so I'm going to reserve my time for rebuttal. Thank you.
Thank you.
May it please the court, my name is Lisa Marie Lerner with the Attorney General's office. On the shackling issue, it's the state's contention that this is unpreserved. His exact language, which I quote in my brief on page 30, is, "What I'm worried about here is this right here. I need my hands free." And he went like this. He didn't object to the shackles. And as to the clothes, he didn't want to wear the county jail clothes. He wanted to wear his prison clothes, and the court granted that. He affirmatively chose the situation in his discussions with the court. And since the error is unpreserved, counsel would have to show fundamental error. He pled guilty, so there's no problem with the guilt phase jury. And in the penalty phase, you have a man who was convicted of numerous armed robberies, including bank robbery, and 3 prior murders in New Hampshire. And this murder was a 4-hour torture session, which was caught on tape, which the jury watched. There's no possible way that appellate counsel could have shown any harm from this evidence. Well, not evidence, but the fact that he was shackled and in jail clothes. And counsel cannot be ineffective for not raising a non-meritorious issue. As to the appeal on the 3851, all of the issues are procedurally barred and refuted from the record without merit, and I stand on my brief unless the court has questions.
Thank you. You can have 2 minutes for rebuttal. You used all your...
Oh, I used all my time.
You did, yes.
I didn't realize that. Thank you, Your Honor.
That's okay.
I apologize.
That's okay.
Just briefly, to respond to my friend on the other side of the aisle, when Mr. Woodbury said, "I want my hands free," that absolutely is an objection to the shackling. That's what he was talking about, and that's what he asked for. I would just ask this court to carefully consider this. We should not, if we're going to keep the death penalty in the state of Florida, which is what the legislature and the courts have held, then we have to be especially cautious and especially mindful that the capital defendant's fundamental constitutional rights are honored, and that was not the case here. I respectfully ask this court to reverse.
Thank you. Okay, our last case today is Willcox versus State of Florida and Willcox versus Secretary, Department of Corrections, numbers 2023-1498 and 2024-0785. Whenever you're ready.
Good morning. May it please the court. I'm Bree Lacey, and I represent the petitioner, Darius Willcox. I'd like to focus the argument on Claim 1 concerning the ineffective assistance of counsel at penalty phase. However, in the rare chance that I have additional time, I will address Claim 2 concerning the Hearst error. 6 attorneys worked on Mr. Willcox's case in the first 9 months following his arrest. None did any work. Mr. Willcox sat languishing in jail without any discovery and any information. And at one point, he told the court he wasn't even completely aware of the charges he faced. Feeling as if he had no other option, he began filing his own discovery motions, his own Brady motions, and then he exercised his constitutional right to represent himself. Following the guilt phase, he then exercised his constitutional right for penalty phase counsel. The court at that time reappointed the RCC, or the conflict office, that was previously on Mr. Willcox's case, and appointed Joseph Walsh. Now, Joseph Walsh wasn't a new player here. He had been on the case in the weeks leading up to the court's granting of Mr. Willcox's motion to proceed pro se. However, at the time, Mr. Walsh was a second chair attorney who was working under Mr. Gershman, who had substantial capital experience. But come March of 2008, when he's appointed as penalty phase counsel, he's now lead counsel. He has no benefit of co-counsel, he has no second chair, and at the time he's in solo practice, and he's in the infancy of developing his own firm. Now, Mr. Walsh had 5 months to prepare for this mitigation phase. Now, it's difficult to conduct a mitigation investigation in 5 months, but it's not impossible, and it was required to be done here. Under established and controlling law, it is counsel's duty to conduct a thorough mitigation investigation. And his obligations are not set aside because he has less time.
Could you describe in detail, because the brief kind of gave generalities as to, can you tell me exactly what you think he should have done that would have been more?
Certainly. He spends in 5 months, right? He sees 5 witnesses himself over the course of 2 days, and over a matter of hours. And in those witness interviews that he's having, he has one general group interview of family members. We know from prevailing norms under mitigation that that's not necessarily how we do things, especially when you're asking sensitive information. It takes time to develop relationships with witnesses. It takes time to develop that information. He doesn't come back and speak with any of those witnesses again.
Well, but again here, what did he miss? What? Now, I've looked at the mitigation that came in the penalty phase proceeding, and the evidence that came in post-conviction. And there's more, no question, but it's in the same general genre. I mean, and obviously he had a very difficult upbringing, very chaotic, dysfunctional, dreadful in every which way. But that comes through in what was presented at trial. Now, can it be, was it expanded on in what you came up with for post-conviction? Yes, I don't deny that. But it's not materially different, or it does not materially, it seems to me, does not materially go beyond what they put in at trial. And so I'm just, obviously counsel can always do more. They can always do more. They can always bring more witnesses. But at some point there, you've got to make choices about how you're going to focus things. I'm just struggling to see how this is either deficient or prejudicial.
I have several answers for that.
I thought you would.
First, the jury did not hear substantial evidence. They heard from Mr. Willcox's mother, LaWanda Willcox, who presented about 23 pages or so of testimony, mostly about her own struggles. But because she was his primary abuser and someone who wasn't in the home where he lived, they didn't have context of him. The jury never heard what actually was happening in the home. They were led to believe that he was under the care and the protection and some shelter from grandma. And sure, some of that was provided, but they never heard the horrific facts of what was actually happening in that home. And so the jury was misled about the evidence that they actually received. Moreover, they never heard any mental health mitigation, right? They never heard any details about the neighborhood he grew up in and what his experience was. They never heard that as a child, he heard gunshots on an almost everyday basis, and he walked over dead bodies in his neighborhood of people he knew. They never heard that at 15 years old and 100 pounds, he went to an adult prison during his formative years while other children are preparing for prom and learning how to drive. That wasn't Mr. Darius Willcox's experience. They never heard this really critical information. When a jury is asked to make the determination of whether someone lives or dies, they need a particularized picture. And this court has said, and the U.S. Supreme Court has said, that sometimes the subject matter does overlap. But that does not necessarily mean that additional information is not needed. And here, the jury didn't hear this information. They heard very minimal. And so the additional information that should have happened is counsel should have presented more information about his life, more context to that prior aggravator that he had, more mental health investigation. But the problem there is because of his inexperience and the lack of guidance he had, he completely failed when it came to the mental health mitigation. And this court has held that his actions surrounding how he handled that mental health mitigation is deficient.
Did he have an expert?
Yes.
And did he rely on the expert?
Yes.
And have we ever held that it is ineffective to rely on an expert, and we will find that ineffective or deficient later?
You have held in Miller v. State that how a trial counsel relies on an expert or how they handle the information that they're relying on can be deficient. And that is, in this case, knowing that having an ASPD finding was not going to be helpful, he still turned that report over to the state. The layers of the mental health handling are deficient in every way you look at it. It's certainly not a per se rule this court has that if you hire an expert and you rely on that expert, then you're completely obviated of any responsibility here or any fault. First, he hires a general expert, okay, even if we excuse that, which I don't concede that that's appropriate. He gets a report with just screening measures and personality testing. Not only does that report have internal inconsistencies that don't support her findings, and even if you forgive him for not understanding that, which I don't concede you should, this expert determined that there were cognitive deficits. Any reasonable attorney would have known in that moment that another expert was required. Additional testing is required because we know that a capital defendant is entitled to a full professional mental health evaluation, which did not occur here. Also, we cannot just alleviate trial counsel's obligation and say, well, this is an expert and he relied on this expert. We also have to remember trial counsel has to present this information to a jury, right? Had he had chosen to put this expert on the stand, he has to understand that expert's methodologies and findings in a way that that expert is able to educate the jury, right? So he would have learned then about the internal inconsistencies and he would have learned more about these findings. But what happened is he waits 4 months.
So what were the internal inconsistencies?
The internal inconsistencies are she uses a screening measure in which she determines that he has no significant psychopathy, which is a measure that is often utilized and relied upon in an ASPD finding. And then several pages later, without going through all of the individual requirements for ASPD, determines he meets the criteria. Also, in some of that analysis, she relies on her assumptions of a conduct disorder she believes he could have had without school records, without talking to any collateral witnesses in the case. But what you have is an inexperienced attorney who waited 4 of the 5 months he had to even send a mental health expert into the jail to meet with him. He gets a report and he has no time. But then his inexperience is even more compounded when he fails to tell the court he needs time. He fails to actually tell the court what's going on. He's got a board certification exam earlier that summer, which clearly mattered to him because he didn't speak to a single witness until after that exam. He's juggling another capital case, juggling a brand new firm, and he's also received very concerning medical news, which require additional medical appointments. He does not have the time or the experience to understand his own failures here and what he's done wrong. And we know from an email on the record that he knew mental health mitigation should have been presented to that jury when he reaches out to the RCC director and asks for additional funding. And in that email, he says, I have to present more than the mother. And he thinks that he can convince the judge to change the mind of the jury, which, by the way, in this case, 7 jurors voted for death. 5 voted for life here. The prejudice is clear. Just one single juror needed to change their mind. They were instructed on 4 aggravators and received 20 pages of mom's testimony, and still they voted only 7-5. This is not the most aggravated and least mitigated case. Mr. Darius Willcox was entitled to a fair and reliable sentence. He got neither. Not only is Porter instructive here on the law as to what was not done, Porter is also instructive on the facts. Mr. Porter, tried in 1987, also represented himself at guilt. And less than 2 months later, he went to penalty phase, having then elected for representation. And his lawyer also only presented the testimony of a single witness. His entire mitigation story also spanned just over 20 pages. No mental health information was presented to the jury. The circuit court in post-conviction determined that there was no IAC, and this court upheld that. However, the United States Supreme Court reversed, finding that all of the additional mitigation that was presented could not be reduced to irrelevant. And you have the same errors in Porter that you have in Mr. Willcox's case, but the errors are even more glaring. In Mr. Porter's case, he was difficult. He didn't want to meet with mental health experts. Mr. Willcox was always participating with counsel. There was never a concern that he didn't want to participate. And in Mr. Porter's case, back when this court and our state had a 7-5 jury requirement at get death, Mr. Porter's jury voted 12-0. Mr. Willcox's jury voted 7-5. The prejudice here is clear. However, the lower court failed in not even engaging with the mitigation, doing the exact same thing that the Porter court did. Instead, the court misapplied the Strickland standard and determined that counsel performed excellently. I'm not sure what we can glean as excellent for waiting 4 months to send a mental health expert in a capital trial in to see the defendant. He treated this case as an afterthought. Penalty phase was an afterthought to him. It was not the integral part of a capital trial that this court has held in State v. Lewis, which is required. And I do realize I'm in a bit to my rebuttal time. If the court has no further questions, I will wait until rebuttal.
Thank you.
Lisa Marie Lerner again with the Attorney General's Office. Your Honors, Mr. Walsh prepared an excellent mitigation case and did a lot of work. Both he and his mitigation expert testified at the evidentiary hearing that they put a ton of work into this case. In fact, between Mr. Walsh and his mitigation expert, they gathered all of the records that existed on Mr. Willcox. So, in fact, my opponent here is extremely diligent, and even she could not find more documentation than what Mr. Walsh found. Additionally, he discussed Dr. Rappa's diagnosis and what she could testify to with Mr. Willcox, and together they made a strategic decision to waive mental health mitigation presentation to the jury. The court held an in-camera hearing where Willcox himself waived the presentation of the mental health mitigation.
Connected with that, could you address counsel's argument that the expert's report, I guess Rappa, that report was essentially incoherent? That somebody reading it could say, this just doesn't make sense. That this is, one part says one thing and another part says something that is not consistent with what the other part said.
The state disagrees. The report is not incoherent. Mr. Willcox's post-conviction experts disagreed with her findings that he had antisocial personality disorder, but that his conduct and his behavior that Dr. Rappa listed in her report, being arrested before the age of 15 numerous times, some of his other answers did support a finding of antisocial personality disorder, as did the fact of his continued law breaking by drug dealing and then this case itself. Additionally, counsel, after the jury came back with a 7-5 recommendation, did get another expert, another psychologist, who testified at the Spencer hearing for the court and essentially went through all of the same information that was presented post-conviction about the neighborhood and the risk factors and the cumulative trauma that Willcox experienced by living in this neighborhood and living in that very crowded and chaotic household.
So how do you respond to the argument that, at least as to that additional information that came in at the Spencer hearing, that the jury, there was really no strategic reason not to present that to the jury?
Except that he hadn't hired Dr. Fischera yet.
Well, okay. Well, is that problematic, though?
No, it is not, because what you have is you have an attorney who has a few months to prepare a mitigation case. He does interview the witnesses. In fact, 2 of the witnesses he interviewed were 2 of the witnesses that testified at the post-conviction hearing. So he talked to them. He knew what they had to say, and that he had the information that they presented at the post-conviction. He also hired Dr. Rappa and talked to her, gave her the records that they had gathered, his whatever school and mental health and whatever records they could find. I remember that they could not find very many school records, but they got all the other records and gave it to Dr. Rappa. Once she wrote her report, it was at that point jury trial is facing, and he can rely on his expert. He's under no obligation, if she gives him a bad report, to go and hire other experts hoping to get a better report. If that were the standard, then we would have defense counsel serially hiring experts trying to get one that gives them something that they want, and that's not the standard. And so, based on Dr. Rappa's report, Mr. Walsh and Willcox waived mental health mitigation evidence to the jury. And after that, Mr. Walsh was so concerned that he went out and fought with his office to get more funding, hired Dr. Fischera in hopes of convincing the judge, based on the 7-5 recommendation, to sentence Mr. Willcox to life. And that's why he hired Dr. Fischera at that point, because he was still working diligently on the mitigation. As to the other issues, the state maintains that the post-conviction court did make appropriate credibility findings, which were supported by the record, and correctly denied the other claims. If there are no other questions, I will rest on my brief.
Thank you.
Thank you. I do have a brief items to address. Yes.
All seem to
one instance. Four. One case, the argument was that he should have argued the voluntary intoxication defense. And the next case up, the argument was he should never argue that. That's the worst thing in the world. See, so like here. Four aggravators, counsel here was able to convince 5 jurors to recommend life, not go with death. So, I mean, it seems like he did some kind of a job to convince that many jurors not to recommend death.
Imagine if he had actually presented the information he had discovered.
Who knows? But he got 5 of them, and that's a feast in the case of this magnitude with 4 heavy, weighty aggravators.
And I think that helps us understand the real risk of prejudice here. And that is, you had a jury that was instructed on 4 aggravators. They returned no findings, not one finding of fact, not as to the theory of guilt, not as to any aggravation. This court struck one of those aggravators on appeal, the avoid arrest aggravator, leaving 3 aggravators. We maintain, as we've established in our briefing, that we don't even know if the jury found any of those aggravators. They made no findings of fact to do so. And there are factual issues when it comes to those aggravators. And this is after presenting just a snippet of Mr. Willcox's life. There was so much more information that trial counsel could have and should have presented. The standard isn't whether he did a great job or tried his best. The standard is, did he provide constitutionally effective representation? A lot of us can do our best and not be great. No matter how hard I try, I am a terrible basketball player. He was entitled to constitutionally effective representation, which he did not get. Counsel had 5 full months to prepare. And as you look at the numbers in this case, I'm a big numbers person. The mitigation specialist spent less than 37 substantive hours on this case, much of which was report writing, in which she took the 3 reports that she had written about interviews, and she put into a larger report. There was not a lot of work in doing our best here. Trial counsel testified at the evidentiary hearing that didn't have a lot of time and he was pressed. And I believe the mitigation specialist testified that they could have done a better job, and they could have. I'd also like to state that I know that the state has mentioned that he gathered records. He didn't use the records. He didn't use information gathered in those records, certainly didn't hire an expert to discuss the possible brain damage that Mr. Willcox may have experienced having been in solitary confinement. And while Mr. Willcox may have waived the presentation of mental health mitigation at the direction of his trial counsel, that was after the morning when trial counsel turned over that report to the state, and then the state stood up during the waiver and said, he's got an access to finding of ASPD. He just waived that mental health mitigation, but the state informed the court that that ASPD finding was there. There was no strategy decision to wait for Dr. Fischera until after penalty phase. His inexperience meant that he didn't do proper investigation and vetting of experts to hire an appropriate expert here. He didn't know how to figure out whether the report lent any use to him. He didn't follow up with his expert. He didn't do the full mental health evaluation that was required. He panicked, and then he hires another expert. And then he gives that first report to the second expert. So now the state is able to ask questions about that first expert that Mr. Willcox waived the presentation of, without that expert having to sit there and undergo cross-examination for her own errors. And so now the state and the court is hearing this information untested. The jury never heard the information necessary here. They never heard a complete story about Mr. Willcox's life, and they certainly didn't hear any information post his time in prison and in the years leading up to the instant arrest. That information was presented in post-conviction. I also want to make the point that while Dr. Fischera may have been more on point and offered that information to the court about the adverse childhood experiences, again, the jury never heard that information, never heard the compelling impact that adverse childhood experiences would have on a child's brain. And Mr. Fischera, as we've argued in the briefing, was not fully prepared. An experienced and reasonable attorney would have known that an ASPD finding, particularly in light of this report, was not the end, but it was the beginning. We ask that you remedy the constitutional error here and that you reverse the finding and grant Mr. Willcox penalty phase relief. Thank you.
Thank you. We're adjourned.
All right.